Okay, good morning, everyone. Thank you for joining us for the SOPPA webinar. My name is Mandy Kalinskis, and I am the marketing coordinator here at Datamation Imaging. So we're going to get this started. I'm going to hand this over to Todd Rowe, who is an attorney over at Tressler LLP.
Good morning. Thank you so much for appearing this morning. I really appreciate your time. I really appreciate Datamation and working with them. Just to give you some quick background on myself, I am a privacy attorney, and I've been in this space now for about 10 years, which is a really long time for a privacy attorney. And during that time, I've worked on issues that would be of scope of international, national, state, local, and industry standards. And one of the things we're focusing on right now at Tressler is SOPPA, which stands for the Student Online Personal Protection Act. And that's what we wanted to spend a little bit of time today on in the first couple of minutes of this presentation and talk about some of the new legislation that's coming down related to SOPPA, give you an idea of what type of obligations you're in for. So really quick, we're going to talk about the legislative intent first to give a good baseline on why these obligations will impact schools and students and the industry that serves schools and students. And one of the reasons that this is so important right now is because we see student data, usually, of course, especially related to SOPPA, belongs to juveniles or people, children under the age of 18. And that is a high value target for a lot of criminals out there right now. First, because you can use that data and nobody may notice that the data is being used for a number of years. If they take my data, there's a good chance that I'm going to go out and try to get financing for a car or something along those lines. If you take an 11-year-old's data, you have about 7 years before that person can really be expected to go out and try to get financing for college or a home. So you have a lot of time with that data. And that's one of the important things about this information right now. And I think that's hopefully why the Illinois legislature stepped up and started working on protecting this data. I should let you know also that Illinois is really leading the way in a lot of privacy statutes. One of the things we work on at Tressler, and we'll use a lot of these acronyms, but we also work on BIPA, which is the Biometric Information Protection Act, and PIPA, which is the Personal Information Protection Act. But Illinois is leading the way in a lot of legislation right now, and I think SOPPA embodies a lot of that. So the legislative intent, which is the best place to start, is the legislature created this, and you'll see this in the statute. And I gave the citation for the statute here on this slide. So if you Google search 105 ILCS 85, you're going to actually see the statute. And I would suggest probably having your legal counsel interpret that statute. But the legislative intent behind this was to create sufficient safeguards to protect privacy and security of data about students, more particularly when it's collected by education technology companies. That's going to be, I guess, longhand today for companies like Pearson or ACT or SAT. These companies that are taking data and making the lives of school administrators easier by collecting, storing, and providing access to that data, but it's also creating another step in that process of the data being used. So that's really the intent, is focusing on how that data is being used by what we'll call ed tech companies. So this is the legislative intent, which is a great place to start. And continuing on with the legislative intent, I wanted to give us a real world example as far as one of the things that I was looking at when sort of breaking down SOPPA a couple of months ago was, how did the Illinois legislator know to be worried about ed tech companies while drafting SOPPA? And lo and behold, we see an example, a real world example of that just this summer, when Pearson, who is an ed tech company, of course, had a large scale data breach. And that it looks like, and we're still, even as we sit here in March of 2020, trying to collect information about what that breach looked like, it looks like there was about 1 million students that were involved in that data breach that had their information compromised in 13 states. So we're talking about a lot of data there. We're also, I guess, more important to our presentation this morning, we're talking about tens of thousands of students that had their information involved here in the Chicago area. So what I've been trying to do is look a little bit at this breach that involved Pearson. And we were called on last summer to assist some of our school district clients with this breach. And one of the things that we saw early on was it was really difficult to get information concerning the circumstances of the breach from Pearson. The school districts had entrusted Pearson with this information, and in turn, the parents and students had entrusted the school districts. So what we saw was a situation where the parents and students were going to the school districts and saying, look, we gave you this information. We don't know what you did with it. If you gave it to Pearson or some other company, we want to know what's happening with that information. So it was really difficult to get information from Pearson to be able to give that to parents. And this situation provides a perfect example of what we're going to see when SOPPA is actually enacted and how that information is going to flow properly and the protocols that should be in place for parents and students to get the information from the school districts, because they're not going to look to the ed tech companies. They're going to be at the school offices wondering what happened. And that's what we did see with the Pearson breach. In preparation for this presentation, I took a look at Pearson's privacy statement on their website just to see if they had the breach reflected in that. And I still didn't see anything about it. I didn't see anything about SOPPA on Pearson's website either. I saw a mention of FERPA on Pearson's website, which is the Family Education Rights Act, and COPA, which is the Children's Online Privacy Protection Act, but I didn't see anything about SOPPA. So that's one thing that we're going to watch for when we look at Pearson or any of these ed tech companies. So let's get into SOPPA and what the requirements are. And one of the places we have to start after looking at the legislative intent would be, what is the information and that's going to be subject to SOPPA or protected by this legislation. And that information is referred to as covered information in the statute itself. And I wanted to give you just a little feel for what that looks like. And SOPPA says that covered information is personally identifiable information or material or information that's linked to personally identifiable information. So really what this means is it's just information that we all would assume would be protected. The information that we have grown to assume retail establishments is going to protect. Those that our names, our addresses, things like that, that if the information got into the wrong hands, they would have a good way to sort of recreate a false profile on us, and that's going to be a problem for us, obviously. One of the places that I looked at, because I'm not really persuaded that this is a great definition as it stands right now, is there was an FBI alert for ed tech companies on September 13th, 2018. Just in case you wanted to Google it, it's alert number I-091318-PSA. And really the importance about that is, first, it outlines sort of the dangers that these ed tech companies may have if they aren't protecting information, and we've already seen that danger, of course. But it also gives a good idea of what the information is in the context of education settings. And we're looking at, as far as the FBI is concerned, biometric data, academic progress data, behavioral, disciplinary, or medical information, web browsing history, and student geolocation. So these are the types of information, this is the type of information that we're looking at that's going to need to have some heightened security put on it. It just seems like common sense that would need to be protected. But really, there's so many different advances in technology coming into schools every day with their kids using Chromebooks and things like that. There's a lot that can go under the radar. So it's a good opportunity to go and sit back and think about what's going to be covered information and sort of do that assessment on a routine basis as well. Also, I wanted to give you the definition of school under SOPPA, and we have that here. And it's really K through 12 is going to be subject to it. And one of the questions we get a lot is, what about colleges? At this point, we're just focusing on K through 12. There is a distinction to be made in the definition of schools and some of the rules and guidelines that we're going to see in a minute. A distinction between private and non-public schools. So we want to get into that, and depending on the type of institution that you have, that's going to really drive how you should be approaching SOPPA. So getting into SOPPA, obviously I could go for hours and hours on SOPPA, but I know that I only have a short time because everybody's busy dealing with all of the news today. But I did want to give you a feel for what the structure looked like. And there's operator prohibitions. Now, operator is a term that's going to be used to describe ed tech companies. Pearson would be an operator under SOPPA. We have operator duties, We're going to focus today on school prohibitions and school duties. There's also state board duties, so that might be worth taking a look at. And then there's parent and student rights. And just as it says, it gives parents and students rights to know about their information. And this really puts more obligations, as we'll see, on schools to make sure that there's a protocol in place so that parents and students can exercise those rights. So the big takeaway today is this is in effect on July 1st, 2021. I can't say that enough. It's July 1st, 2021. You're going to need to have your institution SOPPA compliant. And the interesting thing about this, just speaking broadly about SOPPA right now, is these are objective standards. These are things that you must post on your website to be compliant. So it's going to be very easy to see whether or not an institution is compliant or not. July 1st, 2021, we're about a year and some change out right now. That might be the perfect amount of time needed to make sure that we can institute all of these changes to make sure that you're SOPPA compliant. We're also prepared, and I should let you know that we've created a SOPPA compliance team at Tressler, but we're also prepared to do this compliance within 6 months to a year. That's not the preferred method. We would rather have the time of a year and a half out to really make sure that we have everything in place to make sure your institution is SOPA compliant. But that's where we are. That's the deadline that we're all trying to meet. This is a rare thing to be seeing in a privacy statute as well. Usually we don't see this deadline where things have to be implemented. So it's going to be really interesting to see what type of compliance can be done here. This is a good time to mention also, when we talk about compliance, we're looking at the state attorney general who's going to be looking at whether or not an institution complied or not. So that's going to be the thing. It doesn't necessarily give right to a private cause of action, but you can bet, as we've seen before, that plaintiffs' attorneys are going to look at whether or not an institution was compliant if there was a breach, and that institution that will create additional liability in the private setting if you weren't SOPA compliant. So I listed some of the things here that I think is really something worth looking at. HB 3606 is the legislative history, and that's really important to take a look at just to see what the legislature was concerned with as they were creating this statute. So getting into the school prohibitions, this is section 26 of SOPA, and it's one of the more simple and straightforward sections. There's just two parts here. A school may not do the following. First, sell, rent, lease, or trade covered information. That's the monetary piece behind this. You're going to be able to tell if a school is selling or renting covered information. Once again, covered information is the defined term that we saw on the earlier slide. If there's money being transferred for that information, that's where you could run into problems with this first prohibition. I think the second prohibition is where we're going to see more problems arise, and that's to share, transport, disclose, or provide access to a student's covered information. So here we're not going to necessarily see a school selling information. I think a school knows not to sell student data, although it does happen for college admissions from what I understand. But for the most part, that's easy to see. But a school is really going to have to monitor how it's collecting that data and who it's sharing it with. Not a very easy thing to do. Paragraph 2 does not apply to non-public schools, and this is one of those things that private schools should be following up with on somebody who understands SOPA to find out what those regulations look like for private schools. So that's one other thing right here off the bat. We're seeing a difference between private and public schools. I think thinking about this, the reason that distinction is made is just because public schools have more of an obligation to post information publicly. And so that could be the difference, is that there's no way to have a private school have to abide by some of these rules. So that's probably the reason for the distinction, but something that must be monitored. Let's get into the school duties. So we see the school duties. These are the objective obligations on the school that need to be done by July 1st, 2021, in section 27 of SOPA. So each school shall post and maintain on its website, or if it doesn't have a website, make it ready for inspection, these things. First, we need to see an explanation of data elements. What does that mean exactly? Data elements of covered information. I think that's really, what is that personal information or personal identifiers involved? Is it names? This is a great place the first step will have to be to do a data inventory to know what the school is holding, and then move forward at that point. You need to create a concise explanation of the data elements for the website. So once again, did you comply or not comply? That's going to be very easy to determine because you need to see that explanation. The second one is a list of operators that the school has a written agreement with. This is those agreements that you enter into with Pearson or those ed tech companies. You need to put a list up on the school website. So that will have to be there. This is where we really start to drill down on the administrative responsibilities that are going to be on a school. You need, for each operator, you also have to have the subcontractors to who covered information is given to. So once again, we're expanding that list, and we're putting more obligations on schools to really watch where that covered information is going. And then finally, a written description of the procedures that a parent may use to carry out the rights enumerated under Section 33. Section 33, as we'll see in a minute, are the parent and student rights. So the school is going to have those protocols in place to make sure that the parents and students can learn where their information is going and being used. Another school duty, which is just sort of unique to a lot of privacy statutes, is that schools will have to put together a list of any breaches that they've been involved in, which is even more difficult than it sounds. For example, were you involved in the Pearson breach? Was some of your student data involved in that breach this summer or any other breach? That'll be something that'll have to be posted. Once again, objective criteria that somebody can look at and see whether or not you're SOPA compliant. It's very simple to determine that with having to post things. Another duty that a school will have to do is, and this is really where I call it a contract point person, one person that will have to have the authority to enter into the agreements. The thought behind that is that person will know what agreements are being entered into, which ones are effective at which times. Once again, if you're going to list these agreements on the website, you need to have that point person knowing what agreements are being signed. Oftentimes we've seen not just school clients, but a lot of clients, they might not even have copies of the agreements, and they have to go and search for it. That's going to be something that we're going to have to see a lot less of in the world with SOPA at this point. So we're going to see the creation of a contract point person in order to comply. Another thing that another school duty is that they must put each written agreement on the website as well. This is where I think you're really going to see the difference between public and private schools. So any agreements, parents are going to have the opportunity to go and look at those agreements now and determine how their information is being used. Once again, that legislative intent is to give the parents and students some idea of how their information is being used. I don't know how many parents or students are necessarily going to log on and read the contracts, but they need to be available. This is an interesting, this subpart to Section 27 is really interesting from a privacy standpoint, because if there's a breach, the school has to give notification within 30 days of that breach to the parent and student. Once again, that's, I think, easier said than done. For example, with the Pearson breach, it was really difficult to get information from Pearson. So how will a school inform parents and students about the breach if they can't get information from Pearson about the breach at Pearson? So that can be a very frustrating point. Also, you have to have that done within 30 days. One of the things that we're doing right now for our clients to make sure that they're prepared for this is first creating a protocol so that they know who to contact at that ed tech company. But secondly, have the notifications already drafted and ready to go. And that's something that we've been doing for a long time for our private clients with notifications under PIPA, which is the Personal Information Protection Act. But have a template, have it ready to go so that if there is an incident, you're ready to go and you're not waiting around trying to figure things out. Another interesting development with SOPA will be that schools need to implement reasonable security procedures. And I think this is a place where we would see Datamation come in and determine what are reasonable security measures. And we're going to see courts decide what these reasonable security measures are. And that's going to be really interesting to see how this law develops. Is that going to be by industry? Is it going to be NIST standards, which are NIS standards? Some of our tech people would know that. Or is it going to be comparing school district to school district? So this is going to be really interesting to see how this develops. Finally, another duty will be that a school has to appoint a privacy officer. And this is what we've seen happening a lot in the private sector, is one person probably that person that has the contracts and that has the authority to enter into contracts, looking at all these privacy issues and making sure that they are the contact point for that. A school will have to have a protocol in place also to make sure that they can talk to an operator and get that free flow of information. So another objective standard that the school is going to have to do. Wanted to make sure I got to section 33, which is the parent and student rights. Going through these, you see these things. These, for example, the parents have a right to have information to be collected only through K through 12 school purposes. We're going to need some clarification on that ambiguous term as to what K through 12 school purposes are. So we're going to make sure that we have these protocols in place when you run through these things, that you're only, under subpart B, taking information that's adequate, relevant, and limited to what is necessary to do this. Once again, that's going to be a judgment call for a lot of schools. So this is something that's going to have to be in place. The other thing that's important with SOPPA is to make sure that the school understands that other obligations, such as under FERPA, which we talked about a little while ago, or COPA, are still being met. So this doesn't usurp that in any way. So I wanted to spend a little bit of time, and now that we've sort of downloaded all these huge obligations that you're going to have, at least give you a way out of this. And we put together a SOPPA compliance team with our education attorneys and our privacy attorneys to reach out to make sure that we have these templates in place. So feel free to catch up with us on that. And there's just a picture of our SOPPA compliance team to show you how ready we're ready to go on this. So with that, I'm gonna turn it over. And if you have any questions, feel free, because I'll stick around, of course, and be ready to answer those at that time.
Thank you, Todd. My name is Jim Collins, and I'm a principal at Datamation Imaging. And I'm just going to talk a few minutes here to wrap things up about, tools and handling information as it pertains to SOPPA. It's really, really important that when you look at the privacy and the security around your information, that you have that. And I've been doing this for many years as it pertains to like student records and board minutes and personnel files, but now it's kind of a more overreaching guideline over all your information from all your school information systems. And although this has to be locked down really tight, it still needs to be accessible to the right people. And one of the biggest faults I'm seeing is that a lot of districts are not paying attention to keeping their data and their content for the proper period of time. They're keeping stuff way longer than they should. And to that, document retention and data retention is very, very important. And the longer you keep it, it just creates more risk. It's more data and more ways for a hacker to get in and expose you. So when you do a retention schedule, there's really 3 rules when you do this. And a lot of districts have done this. I would say almost every district's done this. Number 1, all your retention guidelines must be in writing. Number 2, they must be reviewed by legal and your school board. And the third thing is you have to work with the Secretary of State's office with the State Records Archive Unit to make sure you have an approved application before you destroy information and documents, okay? And what is going to happen here is you're going to have a pattern to be able to get things deleted when you no longer need them. And you just got to put this into practice. Last month, we picked up 600 boxes from a school district on the south side of Chicago. And we went through them in about 2 weeks and found that they only needed to keep about 180 of them, less than 30%. And that's just an example of how much the school districts tend to are pack rats and just kind of keep things. And we do have a lot of tools, and I'll show you more as we get into the presentation in a minute about how we can manage that. Well, the document lifecycle is something that I learned in the industry back in the 80s, which just basically talks about the time of data and content and how active and accessible it is. And if we take this and model it over a student health file, it's very active for, say, 4 years in a high school district or 8 or 9 years in a lower district, okay? Obviously, you're in and out of these student files every year. Well, after that 4 years, there's a peak of, say, 3 to 5 years after that where you're still looking at it. An employer verification, a college, a transcript, and you still have some access to that file. And so that's kind of phase 2. And the third phase is the archive phase. You got to keep these things for 60 years, okay? And sounds simple, but it's not. And it also aggregates a lot of data and a lot of paper. All right. Now, if I do this for an accounts payable invoice, we have the same thing, but a different time frame. An invoice could be active for a week or 90 days, depending on how often and frequently you pay your bills. When you get to the semi-active state, it's maybe up to 2 years. And this could be, maybe there's FOIA requests for invoices. Maybe there's legal holds going on in litigation between you and a vendor. Maybe there's issues of payment in a vendor and you're looking at all your contracts and your information as it pertains to a vendor. But the biggest difference is that it goes into the archive state, and in 7 years, you're able to delete these invoices as long as they don't have a legal hold on them. I used to work at Eastman Kodak in the 80s and 90s before I started Datamation, and we were masters of media management. And we would say that in the active state, you're probably better off keeping your data and your images in a digital state because you're looking at them a lot, and that's going to be most productive. In a semi-active state, we would say, well, you should take this data and burn it to an optical disc. We had these 14-inch platters that just held all kinds of data and images, all right? And these were kind of the precursors to CDs and DVDs. And then in the archive state, we were Kodak. We said, hey, let's put this stuff on microfilm. Film is a long-term permanent media, okay? And on that front, current technology, you know, most of all this is being handled digitally now based upon the low storage costs and the capabilities of systems. But if your districts do have a lot of microfilm out there, we do need to talk because we can digitize that and lock it down and make it more secure and private than sitting in a drawer in a roll of microfilm. Managing documents. You know, when I say the term a document, I'm a very broad definition. It can be a physical file. It can be an electronic record on Infinite Campus, Tyler, Skyward, Easy IEP, a transcript system, whatever. All right, it's data. It's in there, and these end up creating documents. Okay, so it's data that you're storing and archiving. And to this, you know, you have to look at this data and these documents and say when students withdraw from your school or data matures and becomes somewhat inactive, you're really better off moving this data and moving this content to a content management system. Here's why. Number one, it lessens the severity of possible data breaches. I can tell you that a good content management system has superior security and privacy over just a line of business application. Secondly, automatic retention rules. These systems have retention. They're going to get rid of data that you don't need to keep any longer than you need to, and I'll show you an example of this. And number three, it ensures compliance. And again, this is magnified with all the data in your systems too that needs to be kept to a manageable level. So let me just show a brief demonstration of this. And I want to go to, this screen is a Tyler cloud-based system. Basically, I have a student file here for a student called Jane Schumacher. And we wrote an integration with this magic blue button up here. And if I click on that, I'm going to say I want to get her file and I want to pull her transcript, okay? So what's happening, and this just logs onto a content management system, and it knows that Jim Collins logged onto the system at 10:30 on the 12th of March, excuse me. And I need that transcript, so I go right to the transcript and I pull it up. And in a couple of seconds, it pulls up that transcript, and the system knows Jim retrieved that transcript. Okay, so I can see that transcript. That's nothing data that's laid over a form. So this is data. It's not necessarily a scanned image. And I need to email this to somebody to fulfill a FOIA request. So I'm just going to hit the email, and what it's going to do is take this document, create a PDF, open up my mail client, and allow me to send it. There it is. So now I can send it to somebody, put a message in there, and I've accomplished this. And remember, the content management system has tracked every step of this. I logged in, I retrieved, I viewed, I emailed. Very, very important things that it keeps track of, okay? Go back here, jump ahead a little bit here, all right? Now, within the system, I talked about retention a lot and districts keeping paper and keeping data too long. You can build retention rules right in the system. And here's a couple quick examples. Delete an invoice in 7 years. Delete a student file in 60 years. These are really good things, but to be able to do this, there's two things that need to happen. Number one, you have to have an excellent document type descriptor. So if you call something a student file or a health file, you have that so that the system knows that those classes can be deleted in 60 years. And the second thing you need, obviously, is the student's withdrawal date. And once you have those two things, you can apply a retention rule and a policy to do that. Now, it doesn't just go out and delete things. It'll send you a pre-warning just saying, hey, I'm going to delete these 800 invoices that are over 7 years old or whatever. And you have the opportunity to delete them or hold back on some of them, whatever you need to do. 2 years ago in 2018, I wrote a white paper. And it basically covers 7 different classes of document types within a school district. And this is a snippet from the school records or student records part. And I've got some things circled here. Yes, a health record and a permanent record for a student, you have to keep 60 years. That's a lot of content, a lot of data, a lot of paper, okay? And you also see that the temp file is only 5 years. And I look at districts, and every district kind of handles this differently. Some districts, even though this is the minority, they keep very disciplined files where they'll have the CUNE file in one section, the permanent file in another section, they'll have the temp file in another section, and the health file in another section. In other districts, and I would say this is the majority, they just have one big old file for that student, and they just put everything in there. So it's something to think about. There are 7 other sections to this white paper: minutes, personnel, buildings and grounds, accounting, business office, superintendent and board records, a lot of things with over 500 document types. So keep this in mind. It's a very valuable thing. It's available on the handout section of this webinar, and the link on our website is up at the top of the screen too. This document is the #1 most downloaded item from our website as well. So it's something that a lot of districts have looked at. You know, in summary, it's really important that you understand these guidelines and you're compliant with them. Whether it's SOPPA, FOIA, FERPA, there's just a lot of burden on school districts to be good stewards of data and content for your students and for your community and for the parents. So we want to present you with tools and methods to provide this security, provide this privacy, and give you the compliance that you need. And like I said, although this is really locked down, you still need to have accessibility to the correct people. So it's kind of a fine line that you need to keep. And the other thing that's a very big challenge to districts is maintaining the content in the paper for the proper period of time and not too long, okay? And with that, I'd like to just say 2 things in summary. You know, if you need information on SOPPA, you want to learn it, understand it, comply with it, appoint somebody, call Todd. Todd is an expert and is a compendium of knowledge on the SOPPA, and he's got a team that can get you guys up to par on this so that you are ready and compliant July 1st, 2021, which is just over a year away. If you've got problems with paper, content management, document retention, you're not complying with some of this FOIA and SOPPA stuff as it regards to your document data retention, we can help you out. So just kind of keep that in mind, because we'd really like the opportunity to work with you. So with that, I'm going to turn it back over to Mandy. We're going to have a couple minutes for a Q&A.
Okay, thank you, Jim, and thank you, Todd. I'm going to pop out the questions now and see which ones we've gotten here. This one's going to be for Todd here. The question is, how does SOPPA apply to informal institutions with learning departments, such as camps, museums, etc.?
It's a good question. That's where I think you would rely on the definition of school. Perhaps that would be your jump off point. And the definition of school is typically K through 12. So that's going to be, now if you're one of those institutions that maybe has K through 12 age students, I think there's a distinction to be made. But a museum, I think, just to give you an answer, a free legal answer today, of course, is I think a museum would not be subject to it. They're also not going to be, I assume, cataloging, organizing, and collecting data with ed tech companies. That's going to be the other thing too. You got to look at the legislative intent after you look at the definition of schools. and the intent behind it was to regulate information that's going to third parties, the ed tech companies. So it's going to be case by case, but those are going to be the two big steps I think that you would have to go down. So thank you.
Yes, I got another one. So this question is, can a school outsource their privacy director to a cybersecurity firm or consultant?
That is a big yes, and we do that as well. So Tressler has acted as outside privacy officers for private corporations for a couple of years. We can do that. Less than that, we can also provide training to the person that you appoint as a privacy officer to make sure that they're up to date on the regulations, and also taking that holistic approach to the data that they're storing, making sure that new programs are accounted for and figuring out how that impacts the obligations. We can do that as well. So yes, of course, we'd be happy to discuss that as well.
Okay, here's another question. Do you know if operators are preparing to work with Illinois schools to meet the new SOPPA guidelines?
That's a great question. I don't know. I really, really hope. And I think that's really going to cause some problems for schools, because what if the operators are not? For example, Pearson is an English-owned company. They are subject to GDPR, which is the European Union's privacy regulations. So a company like Pearson should obviously be aware of that framework and be ready to work in the framework. The problem I think that Illinois schools are going to face are the contracts that they're entering into with these ed tech companies usually are boilerplate, and they're really difficult to get the terms and conditions changed or revised. So that's going to be one of the problems. And you need to look at the indemnity provisions in those contracts as well, because a lot of the ed tech companies are shifting the indemnity back onto the schools. So whether or not that they're preparing, I hope so, because we're really going to need somebody at those ed tech companies as a point of contact to fulfill the obligations that we have to students and parents. So thanks.
Do you have a template for data inventory? Does that make any sense to either of you guys? Okay, Todd does. Okay, he's come back.
I do. I have created a template so I didn't get to go anywhere for Christmas break last year. So I sat down and started scratching out all of these templates. And one of the things that I've done with the data inventory template was looked at first the definition of covered information and broke it down that way. Then I created a table of sense for notes on that template as well, just to run through it. I don't have the technical expertise of, say, somebody like Datamation or somebody in the tech department at the school. So one of the things that I was doing was making sure that I was running through this inventory and cataloging it, or at least giving the schools the opportunity to catalog it. That's the first step, is the inventory. And then I think something that Datamation could help out with would be looking at that inventory and seeing if any of that information is still necessary, keeping information that's not necessary. We look at that as being toxic and just creates a liability. So that's the other purpose of having a data inventory. But to answer the question, yes, we do have templates for that. So.
I do have another one. It's kind of along the same line. Somebody asked if it's going to be necessary to create a position for SOPPA compliance.
So the school's obligation section does talk about creating a privacy officer, and we see a lot of examples of privacy officers, like I said, in the private setting. I think that's what it's going to be modeled as. Now, one of the things, I think part of that question is do we need to go out and to hire a privacy officer? Of course, you could use somebody who offers those services like Tressler to fulfill that role, but you also could have that person that's going to be your contract point person also serving as your privacy officer. I think the intent behind this statute is just to make sure that there's one common element that all the information is running through, so that if a parent comes into the office or a parent logs on and looks at the school's website, they know who to contact. Then the next step is that person that gets contacted is ready to go and knows how to answer, or knows exactly where to get the answer to that question. So whether or not you need to hire a new person, I'm not sure, but whether or not you need a privacy officer, I think SOPPA is going to require that. So.
Otherwise, our last question here is, when students are registering and they provide those proof of residence documents, are those documents going to be, do they need to be compliant under SOPPA, is the last question.
So once again, we're going to look at the definition of covered information and see what that information is that's being extracted. Typically, you're going to see name, addresses, things along those lines, and that probably will be covered data. Once again, that's only going to be covered data for the student, not the parent. So if the parent's trying to prove residency, that could push you into a different statutory framework, namely PIPA, which is the Personal Information Protection Act, which is a presentation all on its own. But I think for the most part, yes, if you're collecting that information, now you're obviously, if you're holding it and it doesn't go to that next step of being put to or sent to an ed tech company, that's going to limit the amount of obligations that you have for that information. But you're still obviously going to need to protect that information against a breach or another incident where you're disclosing that without authorization. So yes, there will be covered information as far as SOPA is concerned.
Oh, we did get one more. So the question is, if you're housing your contracts on the SDPC, can you simply provide that link on your website, or do you actually need to post the contract on your school website?
Yeah, I don't have the slide number right now, but if you look back at our slides, there was one of the school obligations that said the contract or the written agreement would actually need to be posted. That would be our thought on that. And I think you're going to once again see the distinction between public and private schools. At this point, I don't think a private institution necessarily needs to post that agreement on there. But if you look, as far as now whether or not how courts are going to interpret that, there is a provision in there that says the written agreement has to be posted as well. So that's obviously going to be an administrative headache for a lot of folks out there. So yes.
Okay, so this is kind of in the same vein, Todd. It says, in regards to posting agreements / contracts, does that include financial arrangements?
Yeah, I was going to go right back to this slide where we see in the middle of the statute that it says, for inspection by the general public, each written agreement entered into under this act. So to the extent that those written agreements contain financial information, such as the contract amount or things along those lines, I don't see any grounds at this point for redacting portions out of that agreement. So I guess the answer is yes to that. But once again, we're doing a quick presentation in 25 minutes. I would love to sort of drill down and discuss this in length and really figure out what's going on with that. But as for your exact question, yes, at this point, financial information to the extent that it's included in the written agreement.
Thank you again for joining us. And if we have any more questions, we will answer them. Otherwise, have a great rest of your day.